Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here this morning. Some of you are probably looking more forward to this than others. That happens though. Before we get started, I want to take just a few moments and talk about our procedure and introduce our panel. I'm sure that everyone here is an experienced practitioner, but we always feel better if we just basically talk about the ground rules. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. The proper procedure for doing that is after you've come to the podium and introduced yourself to request that from the court. Obviously, appellee gets no rebuttal time. We have a lighting mechanism on the podium, and we believe it to be very straightforward, but we've seen it a bunch. When you begin your argument, the light will turn green. When the light turns yellow, it means you're running out of time. And when the light turns red, it means you're out of time. And we ask that you please respect those time constraints as well. One very important thing, and people tend to laugh when I say this, but all our arguments are being live streamed. What that means for you is you need to think about what you are saying before you say it. Because once you say it, it's gone. And we can't pull it back, and we can't do anything about it. And unfortunately, it has proven to be embarrassing for some attorneys in the past. So please remember that. Let's see, I think that's pretty much everything. I need to introduce our panel. Of course, I've got a couple of newcomers here, so that's funny. Y'all can laugh, okay? Judge Kenny Armstrong from Memphis, Judge Carmen McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Romeashea, Springfield versus Darwin, Eton, MD, et al.
And I forgot to mention, just for everyone's benefit, if there's more than one party to a side, you need to decide how you're sharing your time, and please announce that to the court when you come up, so we'll know what's going on. You want to just pull a chair around?
Your Honor, I don't know that I need a chair up here. I just wanted to make it clear. Megan Lane, I represent Shelby County Healthcare Corporation. We are not truly a party to the appeal. We did file an answer to the administrative order just indicating that we're still down below, but I am here in the event Your Honors have any questions from Shelby County Healthcare Corporation. I'm just going to sit in the back and let the real parties and interests argue this.
Sounds good to me. If you're happy, I'm happy. All right. Anything else before we hear argument?
No, Your Honor.
You may, let's hear from the appellants, whoever's going to make the argument.
May it please the court, I'm Sheila Campbell, and along with Ms. Regina Guy, we represent the appellant, Romeashea Springfield. And may it please counsel. Your Honor, I'd like to reserve 5 minutes for
5 minutes?
Yes,
all
Your
right.
Honor.
You may proceed.
Okay. Your Honor, this case arises out of a healthcare liability action that was brought on behalf of the appellant, Romeashea Springfield, in Shelby County Circuit Court. Ms. Springfield had a surgery in January of 2021, beginning on January 16th of 2021, and had a subsequent surgery on January 23rd of 2021, and had an amputation on January 27th of 2021 by the appellee, Dr. Eton. The statute requires that a pre-suit notice be sent 60 days prior to the filing of a healthcare liability action, and those 60-day letters were sent. This is an unusual circumstance in that the business practice of medicine collided with the obligation of Dr. Eton to provide his business address to the Department of Health. The system that was set up was unusual in that Dr. Eton had an agreement with a company that placed physicians to cover shifts in many different hospitals in many different states. And this was the position that Dr. Eton was in when he came to Memphis on an interstate compact license to provide the health care that was provided to Ms. Springfield. The agreement that he entered into was with Hayes Locum. Hayes Locum had an agreement with Dr. Eton that they would receive notices of his claim as well as medical authorizations. Hayes Locum also had a contractual agreement with the appellee, UT Regional Physicians, Inc., that UT Regional Physicians, Inc., for the services that Dr. Eton would perform, that they would receive any healthcare notices of liability as well as medical authorizations. So Dr. Eton, in completing his application for his compact license, failed to provide a business address for the Department of Health to list his business address on the website. And the health department could not list his home address because Dr. Eton says that his home address in Chicago, Illinois, was his business address, which we know that he was not providing surgery out of his home. He was traveling to many, many different states, Illinois, Florida, Wisconsin, on a weekly basis, providing these services. So,
Let me ask you a question. Is his testimony or his statement to that effect in the record?
yes, Your Honor.
Okay, thank you.
Director Lawrence, who is the director of the Tennessee Health Department that gets licenses and makes sure that medical providers provide the proper information, testified in her deposition that the mandatory practitioner profile questionnaire was sent to Dr. Eton. They asked him to complete that profile. The profile was never completed. The profile provides the data for the attorney or anyone looking at the site to see where a physician's current business address is. So therefore, when he did not complete this mandatory profile, the health department was prohibited from putting his home address on their website. They could not do that without his permission. He testified in his deposition that his home address is not listed on any website. He has not permitted it to be published. So
Does the statute contemplate or provide a remedy for that type situation?
Well, it is the contention of the appellants that once he contracted his right for Hayes Locum to receive notice letters, to receive medical authorization for claim purposes, and that Hayes Locum entered into an agreement that if they were going to assign him to provide these services for UT Regional 1 physicians, that UT Regional 1 physicians had to also sign a accompanying agreement that they would receive those 60-day notice letters and medical authorization. So it is our contention
Okay, but
that...
I understand that's your contention.
yeah.
But does the statute provide a method to send that pre-suit notice in this type situation? Assuming that you don't, assuming the facts that you just discussed.
Well, yes, Your Honor, I believe that the whole purpose of the statute is to provide notice to the physician, and that because of the cross-collateralization of the risk that each of these parties entered into, they were protecting themselves
Okay,
from...
what does the statute say you could do in this type of situation?
The statute says that you can send it to his address on the website, his current business address.
Okay,
And
did you have that?
No, the current business address was never provided, but we contend that in his testimony, that when he came to Memphis to practice, he said the only place he practiced was at Regional 1. So that is where the 60-day notice letter was sent.
Where did the trial court find his current business address was?
Well, that's interesting because the court said that that is not something that needed to be considered because it was not sent to his home address. And I think that was an abuse of discretion by saying that that shouldn't be considered because that is the main focus of the fact that the doctor did not comply with the statutory requirement of putting his business address. He testified his business address was home. The health department said that you can't put a home address on the website as a business address unless they're specifically authorized to do so. They were not authorized to do so. So the last place the statute deals with is to send it to the place where he last performed services.
And did you do that in this case? Did you send it to the address where he last performed services?
Yes, Your Honor. We sent it to the last place and that was the place that was on the internet. 877 Jefferson was the last place that he performed services. So
From my review of the record, you didn't send it to 877 Jefferson. You sent it to 890 Madison Avenue, which is not the correct address. And we know from all the case law that forwarding is not effective to give a defendant doctor notice, and that you've got to get these things right.
Well, by the testimony of Mr. Seitz, who was at Regional 1, he testified that the address for the hospital is 877 Jefferson, but that 877 Jefferson, 890 Madison, they're all on the same campus. They all receive the mail in the same mail room. So that if you mail something to 877 Jefferson or 890 Madison, it is going to go to 877 Jefferson. It is not going to be forwarded. It is their arrangements to receive certified mail.
Okay.
And that is the only place that he provided services. But more importantly, he was contracted to provide services for the whole surgery department. Part of the surgery department is on 890 Madison. It's the same building. One just faces one street and the other faces another street, but it's the same location. and it's the same mail room, it's the same individual that receives the mail, all certified mail. And
And where did the Springfield service occur? What location? Was it 877 Jefferson, or was it 890 Madison?
877 Jefferson,
Okay, so it was 877 Jefferson.
yes, sir.
And your notice went to 890 Madison, is that right?
It went to 890 Madison because on the internet, it was shown that that was his business address was 890 Madison because that was an address for UT Regional 1 physicians.
Okay.
And that's where the 890 came from, was the fact that it was shown on the internet that that was his business address.
Okay.
Thank you. You've used your time.
May it please the court, my name is Jeff Griffin. William Brantley and I represent Dr. Eton. I've spoken with Mr. Vescovo, who represents UT Region 1 physicians, and we'd like to divide our time. I'm going to take 8 minutes, and he'll take 7, so I'll try to speak
Okay, that's
quickly,
fine.
but hopefully not too fast.
Go right ahead.
Dr. Eton was a vascular surgeon who was an independent contractor with an outfit called Hayes Locums. Hayes Locums is a locum tenens agency that provides physicians for temporary assignments in hospitals. Locum tenens is not an unusual arrangement. In fact, it's woven into the fabric of healthcare in almost every community in this state. Locum tenens physicians provide an invaluable service for communities who are underrepresented in certain medical specialties. In that community, they come in, they fill that urgent patient need. He was a hospitalist-based physician, so he never established a business address in the state of Tennessee because he was never here for more than just a temporary assignment. His business address always was and continues to be in Chicago, Illinois, which is what he's based out of.
What is the significance of his failure to register as he was required?
We would argue zero for 2 reasons. Three reasons. One, it has not been conclusively established that he failed to register. I believe the testimony that came out in Angela Lawrence's deposition, who is with the Tennessee Department of Health, is that he would have been sent that form. The testimony of Dr. Eton was if he was sent the form, he would have completed it, but for some reason they don't have the information. So I guess as a factual standpoint, it's not been established that he didn't complete it. Secondly, under the rules.
I mean, it's been established he wasn't registered or you couldn't access it. Is that
Incorrect. No, Your Honor. So what Ms. Lawrence testified to is that at the time that they sent pre-suit notice, had they correctly performed the search in the website, what would have come up is Chicago, Illinois, and his zip code is what would have come up. And that would have been taken off of his compact license application that was sent to them. Under the rules of the Board of Healthcare, if his business address is his home address, he has to give permission to list that. So even if let's assume for argument's sake, he had completed the form and that's been established. If he'd have told them, I don't want this address published, they couldn't have published it on there. That's why the statute gives the alternative for providing notice in this case. It says you send it to the address on the healthcare website and you send it to the current business address because it contemplates the address that you put with the Department of Healthcare may not be your current business address, so it gives an alternate location for that. In this particular case, what's been established is there was absolutely nothing done on the part of the plaintiff outside of a simple Google search and taking the first thing that came back to try to find his current business address, and the court found that was insufficient. Although the case is not mandatory authority, we did cite to the case of Guthrie v. Ball in our brief, which is a very similar set of facts. There's a PA who apparently had an incomplete address that was listed on the Board of Healthcare website, and what the plaintiff in that case chose to do was to send notice to her former employer. The court in that case said that is not sufficient. You've got to perform some sort of investigation to determine what the current business address is. And what's clear from this case is not only did the appellant not perform any kind of investigation to determine whether or not this 890 Madison Avenue was Dr. Eaton's current business address. They didn't do any investigation to determine whose address it was, because as you heard, they thought they were sending it to UT Regional 1, and that's not the address for UT Region 1 physicians. That's been established. The court in this case applied as the standard, which we believe the correct standard to be, strict compliance. The plaintiff does not raise as an issue for appeal that strict compliance was not the correct standard to apply, yet spends their entire brief arguing that they substantially complied with the statute. That's not the standard that the court used in this case, and we believe that the trial court didn't use that standard because strict compliance is the correct standard. Even if it's not the correct standard, they've waived any argument that the court used the wrong standard because it hasn't been raised in any of the briefs that they filed with the case. We believe it's the correct standard. We believe it's correct based on the Bryant v. Vanderbilt case, which basically, as Judge Armstrong made reference to earlier, indicates that indirect notice is not sufficient. There was argument made by the plaintiff about a sort of a quasi-agency or an appointment of people to accept pre-suit notice on behalf of Dr. Eaton. Not only does the statute not contemplate that process and that be something that can be done, but in this case, the two contracts they rely on were both signed years before either Hayes Locums or UT Region 1 physicians had any idea whatsoever that Dr. Eaton would even be coming to the state of Tennessee, or that he would even need to avail himself of his rights under Tennessee 2926-121. In this case, they sent nothing to the address on the website. They did nothing to investigate what his current business address was, and the trial court correctly found that this does not comply with the statute. Even if substantial compliance were the correct standard, which we argue it absolutely is not, Dr. Eaton was prejudiced by the fact that he did not receive the notice in the manner that was prescribed by the statute. That notice was held on to for nearly 2 months before a risk manager, not for UT Region 1 physicians, for the hospital, forwarded that notice to someone with Hayes Locum, who forwarded again to Dr. Eaton, who says, I don't remember when or if I looked at that email to determine what was in there, what the contents of that were. That's not good notice under the statute, and that's not what the drafters of the statute contemplated when they very specifically laid out how notices are to be provided in the state of Tennessee. The fact that he got the notice as late as he did prevented him from having the opportunity to get access to the medical records. In the Vanderbilt case, one thing at least that physician had the benefit of is that physician still worked at Vanderbilt, and that physician was able to get in there and see the medical records and see what the case was about. Dr. Eaton hadn't been back in Tennessee or in Memphis for over a year. He had no access to the medical records at the Med, and therefore could not access those medical records during that 2 months in order to determine what the claims were against him or what the care was that was provided. The last thing, because it's addressed in the brief, I just wanted to say quickly is there was some argument made in the brief about extraordinary cause existing, and we would just say, we don't see anywhere where extraordinary cause exists. I think the Myers Court laid out some examples of extraordinary cause and when that would apply. None of those have been raised by counsel for the appellant in this case. There's nothing extraordinary about Dr. Eaton being a locum tenens physician. It's a very common arrangement. There's nothing extraordinary about him having an incomplete address listed on the Tennessee Department of Healthcare website. In Angela Lawrence's deposition, she was shown the addresses for, I believe, 4 or 5 different physicians that were involved in Ms. Springfield's care at the Med, none of whom had a complete address with the healthcare website. I think one did have a complete one, and it was wrong. It indicated that that physician practices in Baltimore, Maryland, and he's currently working in Memphis, Tennessee for a group there. So this idea that Dr. Eaton having an incomplete address on file with the Tennessee Department of Healthcare website is unusual. Also is not the case. So for all these reasons, we would argue the court applied the correct standard, strict compliance, and that because the notice was not correct, the plaintiff was not entitled to an extension of the statute of limitations, therefore her action is untimely, and the dismissal of her action as it pertains to Dr. Eaton should be affirmed. Thank you, guys.
Good morning, and may it please the court. My name is Chris Vescovo. I'm from the Memphis Bar, and together with Rachel McAllister, we represent UT Regional 1 Physicians, Inc., a physicians group in Memphis that I'll refer to as UTROP. The plaintiff's claims against the principal, UTROP, in this case, which are entirely based on the vicarious liability of Dr. Eton, are barred as an operation of law because at the time the lawsuit was filed, as demonstrated by counsel for the appellee, Dr. Eton, the statute of limitations had run as to the agent. So therefore, the trial court was correct in dismissing the claims against UTROP.
Let's suppose they didn't file the complaint and include Dr. Eton. What should be the outcome in that situation, counsel?
If there were, that would be the situation and the unique circumstances in the Ulch and Gardner cases that came down from the Supreme Court, where they said under the unique circumstances of that case, which was the plaintiff intended to sue and sued just the principal, which they had the right to do. In that situation, there was a conflict with the Healthcare Liability Act such that the HCLA abrogated the common law exception. So that would have been okay as demonstrated by a divided court of the Supreme Court. And that's why our emphasis here is to point out that those circumstances are not present here. And I think...
And the circumstances that you say is not present is the fact that the agent was not sued? Is that...
In Ulch and Gardner.
Right.
Yes.
Why does that make a difference?
Well, that's what the Supreme Court said, number one.
Well, they say unique circumstances, which I really don't understand. What's unique about it? Because in these cases, you can sue the principal or the agent, or you can sue both.
Exactly.
So what's unique about it?
Well, the unique situation is going by Ulch and Gardner, though under the HCLA, the plaintiff has the right to sue and send pre-suit notice to just the principal, to who they intend to sue. In that case, they intended to sue just the principal. And so they then get the benefit of the extra 120 days to the statute of limitations. And so the argument presented to the court in Ulch and Gardner was, well, when it was filed 120 days later, the statute of limitations had run as to the agent who they did not intend to sue, and the divided court, but the majority found that that was a conflict. Two of the justices found that was not even a conflict.
In our case, in Springfield, at the time of the filing of the lawsuit, the claim against Dr. Eton actually was procedurally barred because they didn't send an effective notice.
Correct.
So why is that any different
Well,
than
it's different
Garner?
because there were three scenarios that the court addressed or explained as to why there was an abrogation of the common law exception. And the one was when you just sue the principal, which you have the right to do, you get the extra 120 days.
But you get that because you sent the notice to the principal.
And they intended to do that here. And that there is no conflict with the HCLA had they properly sent notice to the agent. And that's why it's a high bar to find that there's an abrogation of the common law. And that's why the court said, mightily, 3 different times, under the unique circumstances of this case, this is a narrow holding. If they said it is not intended to abrogate the common law framework for vicarious liability claims in those situations where the application to healthcare liability claims would not conflict with the act. So here we have the plaintiff, Ms. Springfield, intending to and wanting to and suing both the agent and the principal. So that's consistent with the HCLA, which says you get to say who you want to sue. You get the benefit of the 120 days if you do it right.
Well, tell me, why don't they get the benefit of the 120 days in their lawsuit against the principal? I understand they don't get it in connection with their lawsuit against the agent because procedurally barred, notice not correct.
Because there were none of those extenuating circumstances here that were in Ulch and Gardner.
But in Ulch and Gardner, because they got the extension at the time of the filing of the lawsuit, the claims against the agent also was barred because it was outside the one-year statute of limitations.
And that's why
I'm trying to understand this exception.
that's
and
why they found-
it's so unique.
That's why they found the conflict. But here, there is no conflict because they wanted to sue the agent and the principal, and that's what the HCLA says you do. You serve notice, you get the benefit of the 120 days. So there's no conflict. They weren't forced in Ulch and Gardner. They said you're going to force plaintiffs to sue agents or principals when they don't want to sue them. Here, they're not being forced to do anything. They're doing what they wanted to do, which was sue the agent and sue the principal. And the sending the pre-suit notice. You send the pre-suit notice to who you intend to sue and name as a defendant, and that's what they did here. So there is no, as the court explained in Ulcher and Gardner, there's no conflict with the HCLA.
So essentially, what you're saying is the plaintiff's the master of his or her own lawsuit, and consequently, if, for instance here, if we find that the agent does not get the benefit of the pre-suit notice, as the trial court did, then that would invalidate the claim against the principal as well.
Absolutely. And that's, it's a high bar to abrogate the common law by a statute, and the Supreme Court was very careful, deliberate in saying, under these unique facts, which are, they just intended to sue the principal. But here, they're the master of their claim, the plaintiff's the master of the claim, and intended to serve the agent with pre-suit notice, intended to sue the agent with pre-suit notice, intended to get the 120 days extension, which is all consistent with the HCLA. And under those circumstances, that's different than in the circumstances of Ulch and Gardner. And that's what the trial court found. And, the operation of law applies in the circumstances of the statute of limitations. The court in Ulch and Gardner said that. They made again, I'll repeat myself, but they made a big point to say this is a narrow holding. So under those facts from Ulch and Gardner, or circumstances, that's different because this is a narrowed holding. If it's in a situation where the application to the healthcare liability claims would not conflict with the act, then there's no abrogation. And so everything the plaintiff did, intending to sue and suing the principal and the agent, that's what they get to do in the HCLA. Serving the agent and the principal with pre-suit notice, that's what they are to do under the HCLA. And suing the principal and the agent, they have the right to do that, and that's consistent with the HCLA. So here, if they had just sued the principal, then under Ulch and Gardner, they would have been okay. But here they didn't. They were the master of their claim, and they sued both. And by improperly providing the notice to Dr. Eton, as demonstrated by his counsel, then at the time it was filed, that claim was procedurally barred by operation of law by the statute of limitations, so the principal cannot be sued.
Thank you.
Oh, I want to make sure you didn't have any other questions.
Well, I'm still trying to understand what is the meaningful difference of those two cases in Springfield when in effect, you can't proceed against the agent. You can't proceed in the two cases cited by Justice Campbell because at the time of filing of the lawsuit, the statute had expired against the agents. Here in Springfield, you can't pursue a claim against the agent because the notice was defective. What is the meaningful difference in the two that somehow Garner is unique?
I think it's that long paragraph in Justice Campbell's opinion where she gives the three scenarios of how this specifically conflicts with the HCLA. And one was they didn't get the benefit of the plaintiff would not have gotten the benefit of the 120-day extension. Here, they would have had the benefit of the 120-day extension had they properly provided the notice. And then number two was in the old situation, you were going to make a plaintiff sue someone they didn't intend, serve someone with pre-suit notice who they didn't intend to name as a defendant. That's contrary to the HCLA. But here, they did serve notice or attempted to serve notice on who they intended to name as a defendant. No conflict. And then the last one was suing. They sued. We didn't make them sue anybody they didn't want to sue. They chose to sue the agent and the principal. And it was those three scenarios that the majority latched onto as to the unique circumstances of that case.
Okay, thank you.
Thank you.
Thank you. Hear from the appellant. I believe you have 5 minutes.
The appellee Eton contends that that the mandatory profile was not asked of him. Well, in the deposition of Director Lawrence.
Ms. Campbell, before you run out of time, can you address this other issue?
Yes, Your Honor. I believe that the exception exists because in Garner, it talks about the 120 days where Garner sent the letter to the hospital, which was the principal, and the statute of limitation was procedurally barred. And they held that in Garner that the plaintiff could proceed against the principal because they had sent
You do realize the facts of your case are different from the facts in Garner.
Well, to file a complaint or to file a lawsuit, if the court holds that the pre-suit notice wasn't properly sent, then the complaint that was filed against Dr. Eton is a nullity. The court doesn't get jurisdiction. It doesn't even initiate a case against him. So to me, it's just a difference without a distinction. If the suit wasn't sent, the statute has run, the lawsuit, I can file a lawsuit against anyone, but the court may not get jurisdiction over it because if I can't procedurally proceed, then it's a nullity. I mean, that's just the plain, rule of law.
But you realize from reading Justice Campbell's opinion in those cases that she said that the circumstances were unique because the plaintiff in those cases only filed an action against the principal, didn't attempt to file an action against the agent. And because of that, that common law, operational law, doesn't apply to bar the claim against the principal.
Well, Your Honor, it just seems that they're very similar in that if the plaintiff, in this case Springfield, is not able to take advantage of the 120 days, then it would nullify the right of the plaintiff under the Health Care Liability Act to assert a right that the act gives her the right to assert.
Yeah, but under the common law, if you're going to claim vicarious liability, then you would bring the action against both the principal and the agent. And that's what you attempted to do here, is that right?
Yes, sir.
But your claim against the agent, I think you've got to understand that that your notice was defective, doesn't comply with the statute, and so you have no claim against the agent. And so now, your vicarious liability claim against the principal may be barred.
Well, Your Honor, that's an issue. We don't believe that our notice against the agent was defective, because we believe that under these unusual circumstances that was created by Dr. Eton and created by all the defendants, because they tried to create this illusion that he was one of their healthcare providers.
Yeah, but all you had to do was serve him either at home, at his home address, or you could have served the correct address for the hospital where the services was provided. That's all you had to do, really.
Well, we believe that this 877 Jefferson was part of the address where he was doing business. It's on the same campus. It's part of Regional 1, the last place that he did perform his services. The only place that he performed was at Regional 1, and the testimony was he contracted to perform services for the entire surgical department. That's at 877 Jefferson, 890 Madison. His contract covered the whole complex.
Yeah, but the statute says you have to give the notice to the address where he provided the service for that party. It doesn't matter that he could provide services at 890 Madison or 877 Jefferson. You have to give the notice where the services was provided to your client under that statute.
Well, in the billing, they represented that that's where the services were performed to her, so I would think that she could rely upon her bill to determine whether they chose that address as where the services were provided, and they sent her a bill. So I would think that she could rely upon the billing statement.
But you know, sometimes the billing office is separate and distinct from where services are provided, right?
And finally, they also held themselves out as using Uthroff's Medicare number and with Medicare, and they used that as the address for Dr. Eton as well. And I wanted to...
You used your time.
Thank you.
Thank you. All right, counsel, we will take this matter under advisement and attempt to get you an opinion at the earliest possible time. We appreciate you being here today and your arguments. You may be excused.